Welcome to Canton Confidential, the Karen Read murder trial. There was a flurry of motions heard today as both sides make their final preparations before the start of round two in the Commonwealth versus Karen Read. Good evening, everyone. Thanks for joining us tonight. I'm JC Monahan.
And I'm Glenn Jones. There will be no court tomorrow or Friday. Opening statements are expected to begin Tuesday. In the final hearing before opening statements, a big dispute about experts from crash reconstruction firm ARCA. We'll discuss what caused lawyers to lock horns.
Plus, the blogger known as Turtleboy says he will plead the fifth if called as a witness. Because of this, Judge Beverly Cannone ruled he doesn't need to be sequestered and can be in the courtroom for much of the trial.
For more on the final hearing before Read's second murder trial begins, we want to send things over to John Maroney.
He has details on what happened in Norfolk Superior Court.
I've been ready. I have no choice but to be ready. I feel strong. I've got an amazing team, and I'm anxious.
Karen Read talking about her murder retrial and opening statements, which attorney Alan Jackson will deliver for the defense.
It's collaborative all the way around. Alan owns it, and he's always open to input.
Read has pleaded not guilty to hitting her boyfriend and Boston police officer John O'Keefe with her SUV and leaving him to die in a blizzard. The 45-year-old defendant says she's been framed.
My attempt was never to preclude ARCA from testifying, never. But it was to preclude the defense from trying this case by ambush.
In a sign of what the trial might feature, Jackson and Special Prosecutor Hank Brennan clashed over accident reconstruction experts from ARCA who investigated the case for federal authorities. The defense is calling them to refute the state's contention that Read hit O'Keefe with her vehicle. The prosecution wants added detail about their relationship with the defense, as well as the scope of their testimony limited.
Nobody's been dragging their feet. There is no ambush. This feigned indignation is just not consistent with the facts, Your Honor.
Blogger Aidan Kearney, a.k.a. Turtleboy, will be able to be in court during testimony, except when witnesses he's accused of intimidating are on the stand. The prosecution moved to bar him, saying they might call him as a witness, but he said he'd only plead the fifth, so Judge Cannone allowed him into the courtroom under the same conditions as the first trial.
Luckily, Beverly Cannone today decided that wasn't necessary, and we walked out of there with a win.
Court is done for the rest of the week. Opening statements will take place next Tuesday. In Dedham, John Maroney.
Michael Coyne, our chief legal analyst, is back with us tonight to help us navigate through what was a very busy day of motions in the courthouse. So let us know what you saw as a couple of the key issues, and what are your feelings about the general sense of the collection of motions as we head into opening statements next week?
Well, I think things are getting tense, and the lawyers have ratcheted up the arguments and the intensity a fair amount. The biggest issue is the crash reconstruction experts. It was the issue in the last case, and we issue even subsequent to the case with respect to whether proper disclosures were made and whether misrepresentations were made to the court. And now they're fighting yet again on the eve of trial about virtually the same thing. Where is the report? What information did they have, and what are they going to testify about? And it is absolutely one of the key pieces in the case, because what you've got to show, and we didn't see it as to the extent we should have in the last trial, is that that vehicle impacted John O'Keefe and somehow disabled him, and then ultimately he froze to death in the snow. And that's what the crash reconstruction experts are going to have to show, both from the standpoint of the prosecution, and the defendant obviously wants to negate that potentiality.
But the prosecution wants only the report that they submitted in February of 2024. The defense is saying, but wait, we have more information from ARCA. Did they hire them and then do another analysis? What is this more information from this organization?
And that's exactly what they're fighting about. If they affix to the earlier version of the events and the testimony that they gave, because of the rules of disclosure, that's the last report they got. They're now on the eve of trial, and what they're fighting about is there appears to be another report of some sort coming, more information, and what Attorney Brennan is arguing is that's patently unfair. We have opening statements on Tuesday. You construct your opening around what you believe your theme should be, and also the evidence that's going to be introduced. You don't want to promise things in the opening that you don't deliver. And what they're now concerned about is there are going to be surprises coming from the ARCA experts and what their testimony is, and in part refuting his experts and the experts the Commonwealth intends to put on, and that's why the fight is so intense, because it absolutely is the key piece with respect to whether she's likely guilty on the DUI manslaughter case.
Sure, yes.
All right, a fight over expert witnesses continues, including the Commonwealth's dog expert. Prosecutors say their expert will testify the marks on John O'Keefe's arm could not have come from the Albert's German Shepherd, Chloe. Reed's defense team is very much opposed to this specific witness. That leads us to a viewer question from Pat. Why was the defense allowed testimony from their dog expert, but the prosecution's expert was denied? And to be clear here, Michael, Judge Cannone has not ruled about this specific witness, of course, but help us understand what she has to weigh as she's making this decision and about expert witnesses in general.
Yeah, what she's trying to decide is whether the science supports both the prosecution's argument that we can exclude Chloe from having caused those bite marks, where there are studies, she already has information, she made reference to it today in court, that there is really no solid science, as she sees it, that supports inclusion. Attorney Brennan is trying to argue, yes, but we could exclude Chloe on the basis of where his teeth marks are, where the injuries were on the arm. And so what he's trying to argue is it falls within the background, education, experience, and training of the expert, and that's what she has to decide to the extent it will aid the jury's understanding of the event. The problem is scientific experts has to be based on science. And what she seems troubled with is, at least in a portion of this, she doesn't believe the science supports the prosecution's witness.
And based on what you heard in court today, you think she's likely to side with the defense on this?
She told him he has an uphill battle to try and get it in, and she'll keep a marginally open mind, but it's a tough fight.
Let's just assume it's not going to happen. All right, Michael, stay right there, because right now we want to switch to text messages. You may remember they did play a dramatic role during the first trial. Today, a motion was filed to get an independent reader to go through messages sent between Karen Reed and John O'Keefe. Here's a little bit of how it played out in court today.
Text messages between Mr. O'Keefe and the defendant, there is no author of those. And so we will introduce those text messages, the admissible ones, at different parts in the trial when they become relevant.
To have a reader come in, it seems to add a theater to the text messages that are inappropriate. I don't know who these individuals would be, and the text messages are admissible because they're statement of a party opponent, and the other is the context of the statement of the party opponent.
All right, joining the conversation now is defense attorney Morjieta Derisier. All right, Morjieta, Reed's defense team does not like the idea of an independent reader. I've never heard of it, so please explain, because the only thing I can think of is, sure, any way you read something out loud sounds differently, depending on how you want to read it. Seinfeld fans, if you remember, it's "these pretzels are making me thirsty."
That's right.
Do you know
That's exactly right.
And then there's another, it's like, "these pretzels, they're making me thirsty."
And as a defense attorney, you want the information, the evidence to be neutral, right? You don't want to have anything read in a particular way that would really point to your client being guilty in any particular way. So I can see where the defense is coming from, where they want this information, if it's allowed by the judge, to be very neutral. And the way you read text messages and the way you write text messages are really different. And I think even in the last trial, there were some acronyms that the judge specifically wanted read out loud because they mean different things when they're texted and when they're read out loud. So it's a point to raise, and I hope that she makes the right decision.
Well, text messages have played such a crucial role in this trial. At least the first time around, we heard ATF agent Brian Higgins read text messages between him and the defendant. Of course, Michael Proctor famously read his crude text messages aloud about what he was saying about Karen Reed. But in this case, with what JC was raising, we could be talking about giving voice to the victim in this case, which seems to be a very delicate thing. Is it appropriate?
Well, the problem with these text messages compared to the ones you just talked about is Karen Reed is not going to take the stand. It appears her father is not going to take the stand either. So who would be the appropriate person to read those texts? Because we don't have the sender or the recipient. That's why they're arguing about neutral readers. But as JC said, it's very unusual. I actually haven't seen it before either. Normally, when you have depositions or text messages of that sort without a foundation witness, then the attorneys would normally read it in, and that that would be the standard practice, because they'll still argue about whether this person is truly neutral or not, and especially with the voice inflection and the thing you put it, whatever you put the emphasis on, we'll still be fighting about this regardless of her decision.
All right, we heard from Aidan, Kearney's attorney today. If you don't know Aidan Kearney, he's known as the blogger Turtleboy. His lawyer said in court, if he's called to the stand, he's on the witness list. If he's called to the stand, he's going to plead the Fifth Amendment, okay? So there was a sidebar. The judge comes back, and Judge Cannone says, yes, there's a solid reason why he should plead the Fifth, and therefore he can stay in court, other than when there are members of witnesses in court who have accused him of intimidation. That aside, what are we supposed to, or should we, interpret anything from the fact that he is staying right up front? I'm not answering a single question.
I think that was the right decision to make. I mean, he still has open pending cases before the court. Any good defense attorney will tell their client to take the Fifth Amendment, especially in a high-profile case such as this, where every single word is going to be dictated and written down. It was the right call to make. And, you know, we'll see how it plays out, but it was the right call.
Well, a layman might interpret his decision as hiding something. Is that fair or unfair to do?
Well, didn't the President of the United States say that if you take the Fifth Amendment, you must have done something? So it's not just ordinary people or others that look at this and say, well, there's something odd here. Remember, the Commonwealth is trying to prove consciousness of guilt. And what at least in part, his theory is, and the evidence does tend to support it from what we've seen, is that Karen Reed and Turtleboy were in contact with one another in an attempt to try and influence the potential jury pool and potentially even witnesses. And the Commonwealth's position is that shows consciousness of guilt. He took the Fifth so that he cannot be compelled to testify against her or even support the Commonwealth's version in any way, because he has that right, because the answer might reasonably tend to incriminate him with criminal activity.
Michael Coyne, Morjieta Derisier, get rest.
You get rest.
Okay? Because starting Tuesday, that's when things really get going. Those were our opening statements. So we will see you then.
Yes.
We will.
Yeah. All right. Quick reminder, again, opening statements expected to begin next week. Be sure to join us here on Canton Confidential, the Karen Reed murder trial. Every weeknight at 7, we'll have a full recap of the latest developments from court, as well as legal analysis from our experts here.
And if you have any questions about this case, send them our way. It's why we have Morjieta and Michael. Use the email address on your screen. We'll answer as many questions as we can.
You want to learn more right now? Well, we have a lot of information on the Karen Reed case on our website, including an interactive chart to help you keep track of all the people involved.